Let's take you live now to the Western Cape High Court where they're hearing an application by suspended Public Protector Advocate Busisiwe Mkhwebane challenging the decision by President Cyril Ramaphosa to suspend her, as well as the process taking place in Parliament. Let's take you there live.
An interim interdict. You can't define an issue to that level, because then you can never, it means, again, let's take this example.
Sorry. Just in fairness to that court, they made a clear distinction between a cause of action and an issue.
Yes, but that's exactly what I'm doing. I'm saying let's forget about res judicata, which is about causes of action. Let's talk about issue, the issue estoppel. Let's confine it just to that. Just confining it to issue estoppel. The issue in the Saldanha J Court was whether the rules were constitutional, right? The constitutional validity of the rules. It went on up to the Constitutional Court. The issue before the Erasmus J Court was not, it was on the assumption that the rules were constitutional. And we were saying that the application of the rules in this, that's why we don't have the proceedings started and so on and so on. So it was a completely different issue. It doesn't work this way that if I go and ask for an interdict, and let's say it's refused, and then 2 months later, the person, the offender, does something else, I can't now go back to court because they say, no, you were here 2 months ago and you wanted an interdict. That's it, you're done. No. Because I'll be saying, I'm now bringing on new facts. This person has now beaten me up or whatever. No court can ever say, I'm not going to hear you because last year you were here on another complaint. That's just completely wrong. A wrong application of issue estoppel anyway. But the point, the reason why I was saying that was just on that point. The point we're debating now is a different one, which is whether, not on issue estoppel now, but on either, I don't quite know whether my learned friends invoke res judicata or stare decisis, but I'll assume they're invoking stare decisis. The issue is that stare decisis doesn't apply for the reasons that I've just explained. Alternatively, if it applies, I'm busy now going to demonstrate that that court was clearly wrong. Now, and I'll do that with the greatest respect if the court allows me. I'm going to do it in a piecemeal fashion. In other words, I'm going to do it now in the context of what we're debating, which is have the proceedings started. When we deal with the other issues, I'll also show how wrong that court was and so on. So I'm not going to do like a full-blown analysis of that judgment. Now, let's come back to the issue at hand, the hard law point. It's the same question that you may pose to that court. What I call the not multiple choice, the secret ballot case. That court, with the greatest respect, is even worse with my learned friends, because it has something like 4 versions as to when the proceedings may start or may not start, and so on. It says at paragraph 95 of the judgment, he, meaning the president, you'll find that at page 239, sorry, my lord, 239, that's volume 3 of bundle B. I know this is duplicated, this judgment. I hope this is not one of the parts where we said we mustn't do it. 239, my lord, yes. And maybe while your lordships are looking for that page, let me sneak, you got it, yes. Let me sneak in a quick point, which must just be at the back of your lordships' minds. That the judgment in part A is on appeal, is being appealed against. Now that's another crucial issue, but we'll come to that. But it must be signposted, and it is being appealed particularly or specifically on this issue and other issues, but on this issue of when the proceedings started. At 95 239, it says, he, meaning the president, only has the power to suspend after the first respondent commences proceedings to remove the applicant. Let me pause there. This is a big issue. We have introduced a ground that says that the proceedings that are taking place now in Parliament are actually not removal proceedings. This is a very important point, because we are saying that those proceedings are not removal proceedings. If the chairperson of that committee has been at pains to tell anybody who cares to know that these proceedings are not removal proceedings, and he's right, because the proceedings there are defined very clearly in the rules. Their function, there's only one function only. It is to determine the veracity of the charges. Now, this is a crucial issue. If those proceedings are about determining the veracity of the issue, then how can you call them proceedings to remove? It's like saying, this example I was making to my team here. It's like saying, when you go to court and you are charged, and you call that imprisonment proceedings, before anybody finds you guilty of anything. I mean, or if you are being taken to a disciplinary hearing at work, they say it's dismissal proceedings. No. These are proceedings to determine the veracity of the charge. Once you are convicted, then you are into sentencing proceedings, or you can call it imprisonment proceedings. So that line is very clear. And here's the problem that my learned friends are going to have. To be honest with the court, even myself, when we argued this matter in relation to Part A, the thrust of the argument was on the fact that the committee in Section 194.1 is the same as the committee envisaged in 194.3a. And I'll demonstrate now that that might not even be the case. And that is why, my lords, we went to, sorry, I'm sorry, my lords. Oh yeah, here we are. That is why, if your lordships go to page, I think it's 27, I think. Yeah, page 27 of bundle, of volume 1.
Bundle B.
Bundle B, my lord, yes. So, I'm sorry. Yes. You'll see we plead this, my lord. Yes, page 27. We plead this, and by the way, nobody responded to this. We say, in respect of the ground of illegality relating to the interpretation section 194.3a, and more specifically, whether the removal proceedings envisaged in that section have indeed started. Very important. In other words, the removal proceedings envisaged in 194.3a, have they even started, irrespective of what is happening in Parliament now? And then we say there are no new material facts, and I intend to rely on the amendments in Bundle A. In other words, it's just a legal point. Then we say the suspension is clearly ultra-virus because the proceedings envisaged in Section 194.3a, when properly interpreted, have not yet started. had not yet started on the 17th of March, and in any event, the current process does not yet constitute removal proceedings. Right? So we say the same thing that the chairperson of the committee has been saying. These are not removal proceedings. Now let's go to the section. And as I say, we make that point clearly in all those paragraphs, and nobody responded. We say, advise full legal argument in support of these submissions will be advanced at the hearing. That's where we are now. So we say, it says, the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. That's what we call removal proceedings.
So the committee of the National Assembly must be what is colloquially referred to as Section 194 committee.
No, that's another mistake. I'll come to that. That's how we've been referring to it, and I'll demonstrate that that might be not quite correct. Let me start by just declaring, I have no doubt that the committee that is sitting in Parliament now is a Section 194(1) committee. That's common cause. The question I'm posing in paragraph 60, 61, and 62 of the supplementary founding affidavit is whether that committee that is sitting there is the committee envisaged in 194(3)(a). In other words, a removal committee for short.
But now if you read the Constitution, seems to be that because that committee that is going to make a recommendation to the National Assembly. There's no other committee.
A lot.
Otherwise, it would mean that we end up nowhere.
No, my lord. With the greatest respect, it's not like that. Let me explain this because this is crucial. We can't apply the logic like that. The question is, what were the framers of the Constitution? What did they have in mind in 1996, not last week, when they were crafting 194(3)(a)? Remember, and this is caused, it's actually almost a natural reaction. When the people were crafted the Constitution, these rules were not in place. There's a 23-year gap between the two things. So we can't say, no, they thought that sometime in 2018 there'll be a committee, and therefore that committee will therefore automatically become the one that they had in mind. No.
No, but now I'm just looking at Section 194 as a whole.
Yeah.
It envisages a situation where there is a committee of the National Assembly which makes the findings.
Yes.
Now
that's the one that's sitting.
And that's the only committee that the section talks about.
Well, my lord, tough luck. If that's the only committee, but 194(3)(a) envisaged another one, then that's not our business.
But that's not how you interpret the Constitution. Otherwise, you make it unworkable. So if there is an interpretation that a liberal provision should be workable, we prefer that interpretation.
Yes, but workable against the rights of a person? No. You can't, my lord. You can't.
Because on your submission, the proceedings could never start.
No.
It never commence because the Constitution is silent on the committee for the removal.
No, my lord. Let me try and explain this. It's this, my lord. What? The question you must ask, you can't say the 194(3)(a) envisages a committee. Therefore, we just look around and say, well, is there a committee in any room here? Say, yeah, then it must be that one that was envisaged. No. The question is the other way around. What is the committee that the framers of the Constitution had in mind when they wrote 194(3)(a)? Full stop. The second question is the one that you and I are debating now, my lord. Whether that committee is the same one as the one envisaged in 194.1a. That's a matter of serious interpretation, and I will demonstrate that the answer to both of those questions is no. And I do it like this, my lord. If you could look at 194, put it this way. Unfortunately, the reason I can give you a brief history of how this came about. We did a case called EFF impeachment case, where After J gave the majority judgment. I'm sure your lordships have read it. And we were making this very point, and fortunately the majority agreed with us. We said you cannot have an impeachment in that case of a president without rules that define each step. Then Parliament around about 2019, then literally copied the rules that were as a product of that case, and adapted them for this purpose. That's important because when they did that in 2019, the question is whether they were answering the question that was posed by the framers of the Constitution. Put it this way, my lord. Parliament, we know that is free. It can do whatever it wants. It's an arm of government. So the Parliament could have said, for example, it could have put 10 committees, if it likes, before you get impeached. And say the other one is going to be called the impeachment committee, the other one is going to be called the appeal committee, the other one is going to be called... Parliament is free to do whatever it wants. This idea that if there's one committee, therefore it must be that one, it doesn't work. Because Parliament could have said, for example, once this committee that's sitting now finishes its work, it will take that work to another committee called a removal committee, which will process the removal process, take it to the president and what have you. Nobody would have said, why are you doing that, Parliament? Because Parliament would say we're doing that to ensure that there is fairness. Now, here's the thing, Justice Nook. Look at 194.1. B, yeah. Public Protector, the Auditor General, a member of the Commission established by this chapter, may be removed from office only on A, the ground of misconduct, incapacity, and incompetence. B, a finding of a committee of the National Assembly. It doesn't say a committee of the National Assembly for the removal of the person. Now, one of the most basic rules of interpretation is that the framers of a statute, let alone a constitution, even worse, don't just put words just for fun. So when the committee is described in 194.3a as the committee for the removal of that person, what is the significance of that? Why is the one in 194.1a just called a committee of the National Assembly? And as I say, it's common cause that is not a removal committee. That's a committee for to make a finding of guilt or otherwise. There's no debate about that. But in 194.3a, they make it clear. And they don't say the committee that we refer to in 194.1a. They say a committee for the removal of the person. In my respectful submission, there is no doubt, there can be no doubt that that is another committee that was envisaged there.
So just so that I understand the argument on this point.
Yes.
Because I understood initially in the first part A, the argument seems to have been that commencement and facing myself evidence leaders.
Yes, I'm coming to that.
So that is not what it should be.
No, it is, Justice Nook.
It's not the same argument that you have.
No, it's not the same argument. I've just said that that's why I was saying, let me start by declaring that was the argument in Part A.
But that's not the argument.
No, it is. It's an alternative argument. It's not abandoned. I'm saying we introduced an argument here, which I just read out, that whether the current process does not yet constitute removal proceedings. And now,
because there is no committee envisaged in section 1943A.
no, because...
No, I'm just trying to,
Yeah.
to understand.
Just to understand the argument. No, it's the other way around. It's because the committee that is sitting is not a removal committee. That's the easier way to understand it.
Another way of saying that there is not, because there is no committee, the fair that is contemplated in section 193A.
Yes, there isn't.
There's currently not. So those proceedings were committee that does not exist. This did not have to comment.
Natural. Okay. No, I understand you, Justice Nook. That's where I'm going. In other words, I'm saying that if we accept that the simple point is to say 194.3A envisages something called a removal committee. A. Tick. Everyone will agree with that. The question is the committee that is taking place now a removal committee? No. And if I am right in both of those, just finished, Justice Francis, if I'm right in both of those propositions, then the question is not, as I say, okay, well then now we've run out of a committee, let's find one. The question is whether the committee that is sitting can be described properly, fairly, constitutionally as a removal committee or not. And then someone who says that is so will then have to explain why the drafters of the Constitution said in 194.1 you must have a committee. And then, but in 194.3A say a committee for removal. And qualified it now this time to say a committee for removal. And that is only in aid of one thing, Justice Nuko. It is not, Parliament will do whatever they need to do, if whatever the implications. The function of this court is much is a simpler one. It is whether the proceedings in 194.3A have started or not. That's all. What the implications and all that, that's not for this court. That's for Parliament to deal with. If the answer to the question whether the removal proceedings have started is no, then that's it. Sorry, I want to make the next point, but I know Justice Francis wanted to ask me a question.
Thank you. Section 194 is removal from office.
Right.
We know section 194, 1 to 3, all deal with the removal from office, or possible removal from office, because it doesn't have to end up in the and that is why I think 194.1 says may.
Yes.
Now, 191B says a finding to the effect by a committee of the National Assembly. So that committee appointed by the National Assembly will merely make a finding
Yes.
as to whether there should be a removal.
Yes.
Not a finding.
Correct.
A finding on the basis of the evidence that might be there before that committee.
Yes.
So, it's, as I understand the process, that we read the rules together with the Constitution, the National Assembly. Well, firstly, there's obviously going to be a motion to say that.
Absolutely, to initiate it.
To initiate. The Speaker looks at the matter, goes to the National Assembly, a panel is then appointed. That panel then makes a final case.
Correct.
And that's where we are with 1A.
Yes.
That's where the final case is. Once that's done, then a committee is established to actually conduct a formal inquiry.
Correct.
Okay? And make its findings and then refer it to the National Assembly.
Correct.
Who will then take a decision.
Correct.
Okay. That's where we are.
Yes.
That's the process.
Thank you.
And that process is described from 94.1 to 94.3. You see, so if you just allow me just
Okay.
to
Okay. Okay, Justice.
The committee referred to in 194.1B can only be the committee that referred to in 194.3A. There's no other committee. The term removal of that person, I don't think there's any magic to it. Merely just said it's part of the process described in 194, merely for the removal. That committee itself doesn't have to decide on the removal. So I think, as you pointed out, just put it to you, that right at the opening of your address, context matters.
Absolutely.
So we need to look at the context within which reference is made to after removal.
Yes.
And that context doesn't mean that committee will determine, merely has to make a finding, which will then be fed to the National Assembly.
Yes. Then I don't know the meaning of the words a committee for the removal of a person. Then it means there's no such, these people were just, I don't know what they were thinking.
It also mean a committee engaged with Section 194 inquiry for the removal of.
No. So, yes, it could mean that. But I'm saying, Justice, and let me take one step back so that I can show you the reason, because we talk about purposive interpretation. The purpose of these things, Justices, is the starting point is that a suspension is something that is prima facie burdensome and an invasion of the rights of a person. This is another, it's probably one of the most fundamental flaws of the judgment in Part A. It's actually one that offends the sensibilities of any constitutionalist that should. And it goes back to what we were debating here earlier. This idea that suspending the public protector is suspending an office, some inanimate thing that has no feelings, has no dignity, is just an office. That's what that judgment says. Why should we worry about, there are no rights of hers that are infringed because it's the office of the public protector that is here. There's no such thing, Justices. There's no such thing. So that problem starts here. And this judgment, quite frankly, once you get this point, then you'll realize that there is nothing that can be put into this judgment. They say in paragraph 77, which is, you'll find it 234. Says here, the applicant on the papers is the office of the public protector. Now, I've just shown, all you have to do is to pick up any volume of this and see where does that come from. The applicant is not the office of the public protector. And then it says, Advocate Mkhwebane is different from the public protector. This may seem...
That part seems to be right.
She is definitely, but once you are wrong on the first one, you are gone. Because if you say the applicant on the papers is the office of the public protector, whatever you say, which may be right after that, is irrelevant. Because, and this is where they miss the boat with the greatest respect, because, and this is crucial. Once you miss that point, that actually what is here is a human being with feelings, with dignity, then you go to what we say in our heads, in the Part A heads. You'll remember we've explained the, at page 60, page 68 of the bundle of heads.
That's your Part A head.
Part A heads which are attached to the Part B heads. Page 68, my lord.
Page or paragraph?
Page 68, paragraph 80.
My page 68, there is only the list of the services.
Okay, then it means the number. All right, it's paragraph 80. It means there's something wrong with the numbering.
Paragraph 80.
80, my lord, yes. If you miss this point...
Yes, that's the one that where, yes. I think it talks to the point that I talked about.
Yes, absolutely. Thank you, my lord. And this, with the greatest respect, whichever way we try to explain it to the Part A court, it just didn't register the way we wanted it to. And that's why there was this thing about the applicant is the office of the public protector. We said it's indisputable as a general rule that any suspension from work limits the suspendee's rights to dignity, reputation, and work. It has been correctly observed, and that's now by a lower court, and I will show you that all our courts have made the same point. This was the Labour Court. It has observed that suspension is the employment equivalent of arrest, with the consequences that an employee suffers palpable prejudice to reputation, advancement, and fulfillment. As if that was not enough, the SCA made the point even clearer. Nugent J.A. said in the Wachenuka case, the freedom to engage in productive work, even where that is not required to survive, is indeed an important component of human dignity. For mankind is preeminently a social species with an instinct of meaningful association. Self-esteem and the sense of self-worth, the fulfillment of what it is to be human, is most often bound up with being accepted as socially useful. But the Constitutional Court put it beautifully per Sachs A in the paragraph 8.
We must use the term productively because of an hold it.
Yes.
A number of issues that we still have.
My lord, this is, if we miss this point, as I say, we might as well go home.
That point is well made.
Okay, yes. Now, what the Sachs J said, I'll paraphrase then, is simply that it says fairness to an incumbent about to be relieved of a high-profile position in public life presupposes the display of appropriate concern for the reputational consequences. People do not live by bread alone. In other words, the fact that you are on paid suspension doesn't mean that you are not being paid. That's where this whole problem comes from. If you miss that point, then you will miss the point that Section 194.3a, because it imposes a suspension, by implication must also afford protections to the victim, so to speak. Now, if you look at 194.3a then with the eyes of a protective measure, rather than an attacking a spear, look at it as a shield for the victim, then the entire picture changes. Because what that section then says is that, and this is not a small matter, this is a matter that is related to the independence of the institution. That is why judges cannot just be suspended willy-nilly, because you have to protect them from, you have to protect their independence. That is why judges have a security of tenure. That is why the public protector has security of tenure. This principle was discussed ad nauseum in the case of Corruption Watch, which is in our heads, in relation to a DPP, Director of Public Prosecutions. This measure, my lords, as I say, if you put the glasses of that this is just to suspend and get rid of you, then you will come with one outcome. But if you put the glasses that says this is a measure to protect the independence of these institutions, and you go back to the certification case. Remember, in the certification case, the original constitution said a public protector can be removed with 50% of the vote, and an auditor general. But that court said no. Constitutional court said no. We have to protect the independence of these offices. Let's increase the threshold to 2/3. Why did they do that? To protect the incumbents from abuse because these are offices, as Mogoeng CJ said, which investigate powerful people. So they have to be protected. Now, then if you look at it like that, it becomes very simple. The Constitution, therefore, wanted to put the point at which a public protector can be suspended at the latest possible time. And where is that time? When there's a finding that that person is to be removed. Because before that, there is no removal process. And this is exactly why the
now after the proceedings of the Section 194.
Of the 194.1 committee, yes. Once the Section 194.1 committee goes nay or yay, then the whole thing then becomes a removal process.
But now all that's left is for the National Assembly to vote on the motion.
It might well be, but remember, the founders of the Constitution did not know what rules are going to be drafted in 2019. Okay, so it's the National Assembly's baby to have structured their business in such a way that it conforms with the Constitution. It's not the business of the court. The only point I'm making is that the court must accept that when the Constitution said after a particular point, then you can be suspended. You cannot then suspend someone before that point has been reached. And that is why, if you go to, you see, this idea of using values to get an outcome, that a predetermined outcome on interpretation is wrong. It's just wrong. And that's why, if you look at page, okay, just the front page of those heads, paragraph 1 of the Part A heads, we put the following preamble, and we were putting it, we were hoping it was going to make the impact, and I say it didn't. It says, you see, the problem is that people use values, and values, you say, no, I'm using accountability. And then we must forget about dignity because we are now using accountability. Then we must forget about equality. Then we must forget about transparency. Then we must forget about openness. Then we must forget about the supremacy of the Constitution. Then we must forget about the rule of law and just flag one value. And this is what Kendrick AJ said about that. The Constitution.
All right, so we come out of those proceedings where the suspended Public Protector Busisiwe Mkhwebane is challenging her suspension from her duties. She's also challenging, of course,